SJC-12231, Joseph Fergus v. Stephen A. Ross.
But you were nice. When I move up to that, I'll tell them to be nice.
Mr. Cohen, good morning.
Good morning, Your Honors. My name's Arnold Cohen. I represent the defendant appellant Stephen Ross. I want to address two issues in this case. My client, who's an attorney, was found liable for negligence because of his failure as a closing agent to ensure that the side loan from Mr. Fergus to Mr. Laverty was secured.
A closing agent is somebody who is an attorney acting in connection with...
Well, in the Reba case, which isn't directly on point with this case, but in that case, the issue was whether, an attorney had to be the closing agent. It was an out-of-state closing company, and the Bar Association brought a claim that they were practicing law without being licensed in the Commonwealth of Massachusetts. So, basically, in that case, and just in general, if somebody's a lender and you're the attorney who's doing the closing, and your job is to see first to make sure that the documents all go on the record properly, but to make sure that the lender's loan is secured, which is a primary thing which lenders' attorneys do, then you have to be an attorney to do that. And in this particular case, and the attorney that Mr. Ross would have had to been was Mr. Fergus's attorney, because what he was faulted with is not protecting Mr. Fergus's legal interests by making sure that the side loan was adequately secured.
So that's quite, that argument that the plaintiff's making, that's sort of a considerable change in the law. Wouldn't it be a considerable change in the law to say that the lender's attorney has this obligation that's been listed to the plaintiff at the closing?
Yeah, it would be a direct change in the law. It would be, I think, would create a conflict of interest. The attorney's representing the lender, he's not representing the borrower, and
so I'm sorry, please finish, I apologize.
yeah, in this particular case, there was a finding that Mr. Ross was not Mr. Fergus's attorney. So there's a contradiction to say that on the one hand, he's liable as a closing agent, and if he was going to be a closing agent for this loan, I mean, the thing that he was said to have done wrong was to have failed to make sure that the loan was secured, which, in this case, you have the added element where it was found that Mr. Ross didn't even know about this side loan.
Now, wait a second. So what happens at the closing? He's there, and he's the one who's also loaning the money, right?
Well,
So he's acting as attorney for himself?
He's acting attorney for this Wisconsin Lending Trust.
Okay,
Which he controls.
which he controls.
He was in control of it, and he succeeded as to be the trustee of it. Although there are beneficiaries of the trust, and it's really, those are the people whose interests he's looking out for, not himself. He wasn't, other than his interest maybe was getting a legal fee for doing the work, but he wasn't really a...
What do we do with Judge McIntyre's findings that you're bound by, that there was no usual referral fee, the price was high, the wife was involved in the appraisal, and that...
Well, that's a couple of different points there, but, first of all, we're talking about apparent authority. And apparent authority has to do with what the plaintiff, based on Ross's conduct, reasonably interpreted by Mr. Fergus, believed, whether Mr. Ross's conduct caused Mr. Fergus reasonably to interpret that conduct to believe that Ross had authorized Laverty to act as his, to be the closing, authorized Laverty to obligate Ross to act as the closing agent on the side loan, and not only that, to make sure that the side loan was secured. So, whether this issue of a commission or not to Laverty, the evidence was that Mr. Fergus didn't have any knowledge of that.
So he didn't know one way or the other?
He didn't know, so he's not relying on Ross's conduct as far as that goes. What Ross may have known, or whether he could have known, or he should have deduced it, or whatever, something about the fact that there wasn't a commission that he was aware of going to Mr. Laverty. As far as Mr. Ross knew, that might have been that Mr. Fergus was giving Mr. Laverty a commission.
So that's just, Judge Green's dissent is that the case is looking at this through the wrong eyes.
Right, yeah, it's not what Mr. Ross thought as far as establishing apparent authority. It's what Mr. Fergus believed, reasonably believed, based on Mr. Ross's conduct. And that just wasn't a factor. You know, that would change basically the law. That's contradictory to the law as far as apparent authority goes.
So do you quarrel with the part of the decision that basically suggests that there was apparent authority in this regard with respect to the loan itself as opposed to the side loan?
Well, you know, as far as the loan itself, if that's where it ended, it really wouldn't matter whether Laverty had apparent authority or not, because the fact is that the court found that there was nothing improper about the side loan.
Right, but I mean, I just wanted to know to what extent those facts that are essentially unchallenged as to the apparent authority with respect to the loan itself carry over to the side loan.
Well, we do challenge that, but the court kind of piggybacked on the finding of the apparent authority with the main loan to make its case as far as the side loan.
Now, what do you challenge the apparent authority for the main loan? How do you challenge that?
Well, we challenged it in our brief. I mean, the fact is that the way this started is that this Catherine Givens was a mortgage broker. She contacted Fergus because Laverty had come to her looking for this $120,000 loan. And she knew that Mr. Fergus had this property that had equity, and that Mr. Fergus could help Mr. Laverty get the loan he wanted. And
But once they got together, Mr. Ross went through Laverty, but he had Laverty as the go-between, right? He didn't have any connection with Fergus until he got there at the closing. He sort of insulated himself and sort of had Laverty do everything. Isn't that right?
Well, our argument, and I think the fair interpretation of the facts is that Laverty was Fergus's agent. Fergus needed to get this loan to complete his project, and he met with Laverty. Laverty had contacts, not just with Mr. Ross, but with other lenders, and he contacted Ross, and he did that on behalf of Mr. Fergus. He wasn't acting on behalf of Mr. Ross. Again, even if that's accepted, though, as far as the side loan, our position is that there's a failure of evidence that would justify the finding of the apparent authority.
Can I ask you about another factual finding that you're bound by Judge McIntyre? She also found, and this is again on the defendant's conduct, that there was an inflated loan amount, and that the fact that he was willing to give Mr. Fergus this amount that exceeded what he needed to rehab the Dorchester property, he should have known that there was a side deal,
Well,
or caused him to believe there was a side deal.
of course, to establish apparent authority, it has to be Mr. Ross's conduct. So
Right, yeah,
the
and
court
the conduct
said
has lended
that,
him a lot of money that he didn't need.
Yeah, so, I mean, there's different answers. There's three different things I would say to that. One thing, like Judge Green said, just because somebody's loaning more than what they need for these renovations doesn't really mean anything. People borrow money. They use property that they have as the collateral for a loan, and they can do whatever they want as long as the lender's willing to give them the loan to do what they want with the loan. Just because the loan exceeded what the amount of the renovations doesn't give a reasonable belief that Mr. Ross is then going to be the attorney for the side loan. The other thing, it's page 9 of the defendant's brief. It says right in it that at that initial meeting, exact words, that they established the $260,000 loan. It was established. Ross didn't establish it. The parties did, Laverty and and Fergus did. Fergus's testimony was that he was the one who decided it. I mean, they met and they basically had a joint, kind of a joint venture on this particular project that this loan was going to be taken out and it was going to be enough to satisfy Fergus's needs for his renovations and also to help Laverty get the $120,000 he needed. That was, so Fergus couldn't believe that Ross's conduct had something to do with this $260,000 figure. It was there right from the start. Also, Fergus testified that he often borrowed money against one property to make renovations on another property or to buy another property. That was his testimony. And I think Judge Green observed that that's one of the reasons why sometimes people take out loans.
Now, there was evidence, excuse me, that Mr. Fergus wrote a note, handwritten note, telling Mr. Ross about this $120,000 side note. Was there any evidence that that note ever reached Mr. Ross?
The trial, there's a specific finding in Judge McIntyre's decision that the evidence was lacking that Ross ever received that. You know, and I think it's important to note that the reliance by Mr. Fergus has to have been reasonable. And, you know, he signed a commitment letter the day before the closing. Presumably, he would have had time to read through it before he signed it. There's nothing in that commitment letter about the side loan. He signed all these documents at the closing. None of the documents said anything about the side loan. He had every opportunity in the world at that closing to say something about the side loan to Mr. Ross, and he didn't. You know, he'd been, you know, one of the, it comes through in the findings of the trial court that he had bought and sold several properties, and he had mortgaged those properties, and it's just not reasonable. It's not right that if Mr. Fergus, you know, that Mr. Ross should be held liable just on this thread that the two, you know, because the loan was more than what Fergus needed for his renovations. It goes against you know, it's a quantum leap from anything that this court or the appeals court has ever held was sufficient to establish apparent authority.
It's not just apparent authority, though. It's apparent authority, and the implications, it seems, is that that an attorney failed to do what he was supposed to do for somebody who wasn't his client. Correct,
and it would expand. This court has made decisions about what the criteria are for establishing an attorney-client relationship, and it's just to say that he's liable as a closing agent, but he's not the attorney is a contradiction. It doesn't make sense, and it goes against the court's precedence on that point. And there's, you know, Mr. Fergus never asked Mr. Ross to represent him, which is one of the elements to form an attorney-client relationship. And sometimes you can be liable to a non-attorney, but in that instance, you have to know that the non-client is relying on your advice or what you're saying. And there was no evidence. The evidence was the opposite of that Mr. Ross didn't have that knowledge. You know, it just seems to be defy.
Assume for the sake of this argument, I know that you say it's factually untrue. Let's imagine that Mr. Ross actually knew of the side loan. Would it matter?
Well, I would submit that, say Mr. Ross knew that was happening, unless he was asked by Mr. Fergus to represent him and to make sure that the side loan was secured by a deed in lieu or a mortgage or whatever way that you could do it, or to advise Mr. Fergus that, you know, that it really wouldn't matter him having knowledge of it because, you know, he has to be asked to step in and do something about it.
Would it matter if he knew that it was understood that it was going to be a deed in lieu of foreclosure that was going to be exchanged where that was not, in fact, being done?
Well, I think if, say, Mr. Fergus or Mr. Laverty told him, hey, look, you know, we're going to take $120,000 from this, for the proceeds here, and I'm going to give it to Mr. Laverty, say Mr. Fergus is the one who's bringing this to Mr. Ross' attention, and he's going to give me a deed in lieu. Would Ross, I mean, that's a hypothetical question. I mean, I'll be honest, I can't totally answer it. I think that in that case, Mr. Ross would have followed up on that and asked questions about it, and the result very likely would have been different if that had happened, but it didn't.
Okay, thank you.
Thank you, Your Honor.
Good morning, Your Honors. If it would please the court, my name's Attorney Gordon Feener. I represent Mr. Joseph Fergus, who is also present in the courtroom in the back row of the gallery, and with me is my associate, Danielle Worley. It is our position that the decision of Judge McIntyre and the affirmation by the appeals court should be upheld. Judge McIntyre issued a 21-page opinion, and that record indicates that she had asked appropriate questions during the course of the trial in order to clarify her understanding.
Okay,
It is our
help me to understand precisely what it means. That Mr. Laverty was the apparent agent of Attorney Ross, and therefore, what is the consequence of that?
I suggest to the court, Your Honor, that the evidence at the trial was that Mr. Laverty had acted in prior cases on behalf of Mr. Ross, and that during the course of this particular transaction, that the court needs to look at all the attendant circumstances.
But my question's a bit different. My question's a bit different. My question is not, was there evidence to support the finding of apparent
My
agency?
apologies.
That's a separate issue. My question is, let's assume there was. What is the legal consequence of Mr. Laverty then being found to be the apparent agent of Mr. Ross?
If he is the apparent agent of Mr. Ross, then I would suggest that Mr. Ross, Attorney Ross, was bound by the actions of Mr. Laverty.
And what does that mean here?
That,
He was bound by the actions of him.
including the arrangement of the side loan for the $120,000. So if there were,
I'm sorry. I apologize. Keep going.
I would suggest then that the Laverty's knowledge of the side loan then would be imputed into the knowledge of Attorney Ross under what we maintain is the restatement third of the agency, which we cited in our brief.
So what? I mean, Mr. Ross knows about the side loan. That doesn't get you to him being responsible to make sure that Mr. Fergus's security interests in the $120,000 is going to be protected. That's the part that I'm not getting. How do you get from agency to Ross assuming that responsibility? What was it that he did that would communicate to Mr. Fergus that Mr. Laverty was his agent and that he was supposed to take care of this for Mr. Fergus?
I understand that, Your Honor, Justice, to be a twofold question. And I would suggest that the issue of knowledge with respect to the loan, that Mr. Fergus, and I believe it came out at trial, that Mr. Fergus would not have made the loan but for the guarantee that he was going to be given a deed in lieu of or some type of security
Okay, guarantee by whom?
by Mr. Laverty.
Okay,
Okay, and if that is the knowledge that can be imputed upon the actions of Mr. Ross, I would suggest that Mr. Ross is bound by whatever statements Mr. Laverty would have made in order to encourage that loan to have gone to Mr. Laverty for the $120,000. So I think you have to look at it respectfully as a total package, that it was not only the arrangement for the loan, but Mr. Fergus would not have made the loan but for the having the guarantee of the deed in lieu of. This, if respectfully, Your Honor, Mr. Fergus did not know anything about Mr. Laverty. This was his first interaction with Mr. Laverty, was with respect to this meeting that had taken place. So what he is doing here, he's basically loaning money to a stranger, someone he did not know.
Why did he do that?
In hindsight, it was a foolish thing to do, and I think Mr. Fergus acknowledges that fact. But what he saw in this was the opportunity to obtain the money for him to finish his home that he was working on for the purposes of living in it. And I would suggest that that issue of the home is a significant issue because this was not truly a commercial transaction as the documents that were drafted by Attorney Ross would suggest.
So with the apparent agency, you're essentially saying we should treat it as if Ross was Laverty,
Absolutely.
do all that Laverty knew, and was responsible for what Laverty did.
That is correct, Your Honor.
But isn't that then a breach of contract, that Laverty promised to give him this deed and never did? In fact, it's sort of a strange contract because he couldn't have given him the deed since he didn't own, or he could have basically said, after I'll use the money to purchase the property, and then having purchased it, I will then give you this deed, and that there was a breach. But the finding was not breach of contract. The finding was breach of a duty of care and negligence. That's what I'm trying to sort out here.
That's correct, Your Honors. We know more now in hindsight than what we had known at the time that the case was brought and the way the case was formulated. Although we do not agree necessarily with Judge McIntyre's decision with respect to the contract issues or or some of the other rulings that she had made, we chose, or Mr. Fergus has chosen, not to appeal the judge's decision and then basically defend the judge's decision that she made the right decision with respect to the issue of negligence. But
if it's negligence, then you had to say he had a duty of care to Mr. Fergus, but deriving from what? Because he was involved in selling him property? Or he was his agent? I'm sorry, his agent was involved in obtaining a loan, and therefore he had a duty of care? I'm trying to sort out how this works.
I would suggest that Attorney Ross had a duty to care, a duty to Mr. Fergus. And I would suggest that when you're looking at the duty here, you need to take into consideration all the attendant circumstances, including the fact that a fee was paid by Mr. Fergus to Mr. Laverty, in which, although the court did not find that it established an attorney-client relationship, there was in fact money that was paid to Attorney Ross for the handling of this transaction, which included not only the initial loan, but the side loan and the deed in lieu of. So this was a multi-elemented, for the lack of a better word,
He
transaction.
prepared all those documents?
Excuse me?
He prepared all those documents relating to the side loan and to the deed?
No.
Mr. Ross
No,
did?
Mr. Ross did not prepare those documents. He only prepared the documents with respect to
The $260,000
Right,
loan.
with respect to the Wisconsin Trust portion of it, that is correct.
Right.
And that is
So why does his obligation extend beyond that?
because of the communications of Mr. Laverty.
Wait,
So
wait,
Not known to Mr. Ross? No proof that they were known to Mr. Ross?
there was no evidence at trial that would confirm that that was in fact known, either way, whether it was known to Mr. Ross or not.
what's the general duty of care that a lawyer owes to a non-client?
I think the general duty of care that an attorney owns to the non-client is spelled out in part under the professional rules of conduct. And this is why, in part, we maintain that we're able to rely upon the professional rules of conduct, and that Attorney Ross should have taken reasonable steps under his obligations as an attorney to provide some at least basic protections to Mr. Fergus. It is undisputed that this closing took place in near record time. There was contradictory testimony of whether it was 15 minutes, 20 minutes,
You know, what troubles me is I think you're coming awfully close to a concept of a lawyer for the transaction as opposed to a lawyer for a client.
And part what, if I may digress for a moment, please. And that's part of what our argument and what we argued in the brief was, that although the Reba case kind of sets out what the standard of care is and some of the duties are that an attorney is obligated to with respect to a real estate transaction, it doesn't really address the situation in which an attorney is acting as a closing attorney for a loan, and I would suggest that that is the significant key of this transaction, that this wasn't really a real estate transaction. This was a loan that was being made by Mr. Ross, of which Mr. Ross was in fact the decision maker, and there was evidence, or the Judge McIntyre found that there was an issue as to whether or not there was ever a trustee or Mr. Williams ever existed, and whether this was just something that was set up to allow Mr. Ross to engage in these high-interest loans. This is why I suggest, this is why we suggest to the court that it is appropriate for the court at this point to expand the REBA and adopt a standard that has been set forth by the federal government that more closely addresses closing agents. And I would suggest that the code that we had attached to our brief specifically addresses the situation where closing agents have a financial interest in the subject of transaction.
Can the appeals court decision remain if we don't do that? In other words, is there something in our existing cases that would say that you don't need an attorney-client relationship between Fergus and Ross for Ross to have the duties that a reasonable attorney would have in this situation at this closing, or does that holding require a change in the law?
I would respectfully suggest, Justice, that the court can uphold the appellate decision with respect to the decision of the trial court, and that this court can take this opportunity, as we have argued in our brief, to expand the law with respect to the Reba case, and that the court can expand excuse me, please, that the court can expand the law to address these types of situations in order to provide protection, because I would suggest to the court, Your Honor, that the decision of the Reba case clearly set forth that the reason we don't want independent businesses doing closings is to provide protections for the consumer or for the individuals as a whole. That we want an attorney there because the attorney is going to be in the best position under his obligation of professional responsibility to take the necessary steps to be able to explain and assure that the rights of all individuals are protected.
Right. I understand and appreciate your argument. And my question is, in order to uphold this verdict, does it require that expansion of Reba that you're talking about?
I do not. I believe that the court can uphold the decision of the appeals court without expanding, because I would suggest that this case can be very narrowly construed going forward, because in this particular case, we did not have a real estate transaction per se. We had a loan closing, and that this case, as decided by the appeals court, would only be applicable to those situations in which an attorney was engaging in a closing where that attorney had a financial interest and where that attorney is in fact engaging in high-interest loans. So although the appellant is arguing that this was a far-reaching decision that would apply to every situation, I would strongly and vehemently disagree in saying that, no, it wouldn't apply to the normal real estate transaction that would take place. That the case is limited to the facts, and the facts of this case are those facts in which an attorney, a member of the bar, is engaging in these high-interest loans, creating documents that were applicable to Mr. Fergus, who was looking to rehabilitate or continue the rehabilitation of his home, a residential dwelling. So for that, we maintain that based on the facts of this specific case, that the holding of the appeals court would be significantly limited to those facts.
Does your argument depend upon Mr. Ross knowing that there was a promise that the $120,000 loan would be accompanied by the deed in lieu of foreclosure?
No, Your Honor, because we maintain that the fact that Laverty was Ross's agent gets us to that point.
So you're imputing that knowledge to Ross regardless of whether he actually had it?
Absolutely and without question, and I would maintain that that position is supported by the restatement third.
All right, thank you.
Thank you, Your Honors.